Carried. Carried. Ready? Ladies and gentlemen, the verdict has been reached in this case. Before the jury is brought back in and the verdict is read, I want to remind you that we don't need to show a bunch of emotion or have any outburst in this. Granted, this is an emotional case, and I know it's a very personal case to many of you. However, we need to maintain the order in the courtroom and the proper courtroom decorum. So therefore, I'm cautioning you to remain under control of your emotions as best as possible. Let's please bring back in the jury, if we would. Mr. Holt, I understand you're the jury foreperson, and has the jury reached a decision in this case? You're fine.
Yes, sir, we have.
Okay, and is that decision, is it reflected in the verdict forms?
Yes, sir.
All right, thank you. Make it sound. Count one, verdict form one, State of Tennessee versus Zakkawanda Moss, a.k.a. Face, Lincoln County Circuit Court case number 13 CR 63. We, the jury, unanimously find as follows: that the defendant, Zakkawanda Zwamba Moss, a.k.a. Face, is guilty of first-degree murder in the death of Amber Deshay Leslie McCauley, owner about October 21st, 2012, and or October the 22nd, 2012. If that is your unanimous verdict, would you please each raise your hand? Let the record reflect that each juror has raised their hand. Count two, verdict form one, State of Tennessee versus Zakkawanda Zwamba Moss, a.k.a. Face, Lincoln County Circuit Court case number 13 CR 63. We, the jury, unanimously find as follows: that the defendant, Zakkawanda Zwamba Moss, a.k.a. Face, is guilty of first-degree murder in the death of Rashad O'Brien Ragland Jr. excuse me, on or about October the 21st, 2012, and or October the 22nd, 2012. If that is your unanimous verdict, please raise your right hand. Let the record reflect that all 12 jurors have raised their right hand. Count three, verdict form one, State of Tennessee versus Zakkawanda Zwamba Moss, a.k.a. Face, Lincoln County Circuit Court case number 13 CR 63. We, the jury, unanimously find as follows: that the defendant, Zakkawanda Zwamba Moss, a.k.a. Face, is guilty of first-degree murder in the death of Shambrea Rael Campbell, owner about October the 21st, 2012, and or October the 22nd, 2012. If that is your unanimous verdict, please raise your right hand. Okay. Let the record reflect that each juror has raised their right hand. Count four, verdict form one, State of Tennessee versus Zakkawanda Zwamba Moss, a.k.a. Face, Lincoln County Circuit Court case number 13 CR 63. We, the jury, unanimously find as follows: that the defendant, Zakkawanda Zwamba Moss, a.k.a. Face, is guilty of the first-degree murder in the death of the unborn child of Shambrea Rael Campbell, owner about October the 21st, 2012, and or October the 22nd, 2012. If that is your unanimous verdict, please raise your right hand. Let the record reflect that all 12 jurors raised their right hand. Count five, verdict form one, State of Tennessee versus Zakkawanda Zwamba Moss, a.k.a. Face, Lincoln County Circuit Court case number 13 CR 63. We, the jury, unanimously find as follows: that the defendant, Zakkawanda Zwamba Moss, a.k.a. Face, is guilty of the first-degree murder in the death of Jessica Lee Brown, owner about excuse me, October the 21st, 2012, and or October the 22nd, 2012. If that is your unanimous verdict, please raise your right hand. Okay, let the record reflect that all 12 jurors have raised their right hand. Count 6, verdict form 1, State of Tennessee versus Zakkawanda, Zwamba Moss, a.k.a. Face, Lincoln County Circuit Court case number 13-CR63. We, the jury, unanimously find as follows: that the defendant, Zakkawanda Zwamba Moss, a.k.a. Face, is guilty of first-degree murder in the death of Warren and Vincent Crutcher on or about October the 21st, 2012, and or October the 22nd, 2012. If that is your unanimous verdict, please raise your right hand. Let the record reflect that all 12 jurors raised their hand. Okay. Before the jury is discharged, are there anything that either the state or the defense needs to address?
Only from the state, Your Honor, to thank you to the jury for their time, effort, professional attitude. We appreciate that.
Okay. Let me address you guys. First off, I want to thank you for your service. This has been a long, difficult case, and that you have provided service to your county, and for that we are very thankful. You've been taken away from family, friends, your business, and you've made a great sacrifice for our way of life here in the United States, because this is the way we do business in our criminal justice system, unlike perhaps other countries. I want to talk to you about confidentiality for a moment. That may be in the back of your mind. You don't have to discuss this case with anybody. If somebody approaches you and to talk about this case and you don't want to talk about it, you tell them. If they insist on talking with you, then you'll need to contact the Lincoln County Sheriff's Department or my office, and I will take care of that for you. Okay? However, you are now free after you're discharged to discuss this case with whom you please. However, I ask that you, if you do so, that you take into consideration all the parties involved, particularly the victims and the victims' families, and consider their privacy when you're doing so. And consider that the decision and the opinions of your fellow jurors when you talk about this case, if you decide to talk about this case. During the deliberations, each juror freely discussed their opinions about this case, and they did so in confidence, and so we don't want to breach that confidence. And so therefore, when and if you decide to talk about this case, please bear those things in mind. Again, I thank you for your willingness and your time to serve as a juror in this matter. I know it's taken you away from a lot of things in life that you could otherwise be doing, and for that we're deeply appreciative. Is there anything else, General?
Not in front of the jury.
In front of the defense?
No, sir.
All right. You may now be excused. Thank you. Of course, there's but one sentence for this defendant. However, there are multiple counts which will require the court to make a decision on whether it's concurrent or consecutive. So therefore, we're going to need to get a pre-sentence report accomplished. Let me throw out some dates to you guys. I've also toyed with the idea of, I don't know how much proof the state wants to put on, and it may be something where we need to pick a special day. At the present time, we have January the 7th, January the 21st, February the 4th or the 18th, March 4th or the 25th. Now, the February dates are fairly well taken, at least by part one of this court because we will be trying the co-defendant during that month. So I am open to suggestion on whatever date you want, and we could put these dates tentatively with the understanding that if the state and the defense believe that this is going to be a protracted sentencing hearing, then we can select a special date for that too.
Of the date you provided, that second date in January would be our first selection. Otherwise, we can make do on any of them. That's the second January date.
Mr. Cover,
Which was the second January?
21st.
Yes, 21st is fine.
Okay, that's outside the 45 days, I believe. All right, thank you.
And along those lines, right, my memory is there was no bond in this case. I don't know whether there would be along the front.
No, that's not an issue.
Just to be safe, if there was, we'd ask you.
There's no issue as to bond. There is no bond to be had. All righty.
I'll tell you also, Judge, typically my practice is at a sentencing hearing, and obviously prior to the sentencing hearing, I will file a motion for trial.
Okay.
And so immediately following the sentencing hearing, it's my goal to do my motion for trial.
You want to do it also on the 21st of January?
That's right.
Okay. Now, typically, a lot of lawyers will do it, within 30 days thereof, but
I just like to get it taken care of, so I don't run into any timing issues with respect to that.
state appears to be in agreement with that.
I'll file my motion.
Okay. Would you copy my office?
Yes, sir.
All righty. Will there be anything further in this case?
I would ask, who's going to contact anybody with respect to interviewing my client for prisoner?
The clerk will.
I guess I'll talk to the clerk because I do not want my client to interview without me getting the message.
Okay.
I'll follow up.
And we'll have to discuss, and where he's housed at the time, too.
Yes, sir.
Okay. All right. Is that it? All right. You stand adjourned. Thank you.
Thank you.